Welcome to Financial Poise's episode 1 in the commercial litigation funding series titled Commercial Litigation Finance. This is a 2-part series, and for future planning, the live broadcast of the second episode is scheduled for May 29th. So mark your calendars. This series is co-produced by the National Law Review. The National Law Review is a legal news website that provides comprehensive coverage on legal topics, expert analysis, and daily news updates. You can read more about Financial Poise on slide 47 and the National Law Review on slides 3 and 46. We'd also like to take a brief moment to thank our sponsor, Max Asset, an online provider of asset sale and auction solutions. You can read more about Max Asset on slides 4 and 45. So just briefly to set a little bit of the stage, litigation finance is a funding vehicle that's come into use primarily to deal with things like increasing costs of litigation, extended case timelines, burdens on litigants, and it's a valuable tool for parties to commercial litigation to facilitate the prosecution of their claims. It's a global industry, but for the purposes of this episode, we will be focusing our discussion on the US market. Some numbers: Westfleet Advisors recently published its 2024 report on the state of the litigation finance industry. And looking primarily at US commercial litigation, not mass tort or consumer litigation, Westfleet identified 42 active funders who committed $2.3 billion to 287 new deals in 2024. The average deal size for a single matter was $6.6 million and $16.5 million for a portfolio transaction. And we will explain more about those distinctions in the program. Another survey of 400 senior in-house lawyers and finance executives revealed almost 75% had either used litigation finance or considered it. Nonetheless, it's still a relatively young and developing industry. It's about 15 years old. To discuss this industry, the nuts and bolts, trends, and tips, we've assembled a great panel. Stuart Ackerley is a director at Statera Capital, is a provider of funding solutions for mid-sized commercial claims, and he's formerly a commercial litigator at an AmLaw 150 firm and law clerk, among other experiences. Jeremy Weitzman is a business and finance attorney at Motschellis, who, among other practice areas, advises clients on litigation financing matters. And Paul Haskell is a business and finance attorney at Kroll & Mooring, who advises clients on litigation funding matters, funders, and participants, and distressed debt and claims trading. You can read more about my and their bios on slides 39 to 42. And the last thing before we kick it off in earnest, you are not our clients. We are not your lawyers. What we do here today is for your general education and not for you to act on without appropriate advice. See slide 5 for the disclaimer. Jumping into the meat of the content. So I start with a softball for Jeremy. What's litigation finance or funding?
Thank you, David, and thank you for having me here today. In a nutshell, litigation finance, and you've already touched on this a little bit, David. The litigation finance is a third party kind of funding the costs of litigation in exchange for a partial return from that litigation. And that's at the highest sphere, broadest sphere. What we're talking about today is a subset of that, right? It's commercial litigation finance. So what we're talking about today is not things like, as you have identified on the screen here, mass torts, right? This is not the, hey, I'll give you 70 cents today for the dollar you'll get tomorrow, or class actions or consumer, the slip and fall. What we're talking about here is commercial transactions typically between business entities, where there are, there's lots of damages at stake. So think business disputes, think patent disputes, again, big disputes. And why this is a relatively new, I know we'll get into it, is there's some legal principles and others that come into play. But again, the nutshell here is it's a third party unrelated to the transaction that funds part or all of the transactions in exchange for a share of the recovery. And it's typically on a non-recourse basis.
Right. So I think, as listening to your explanation, I think of litigation finance as funding the costs of the attorneys who are prosecuting the case during the trial phase, discovery, and trial itself, maybe the appeal. The Westfleet survey that I had mentioned indicated that funders allocated 26% of new capital to monetization. So Stuart, that's a little bit different than what I just described as maybe the basic structure. Can you tell us a little bit about the different products and solutions that are available in the market?
Sure. So I think what you've identified, David, the funding of legal fees and expenses is the traditional use of litigation funding, at least in the commercial context. I think over the years, several other uses have also materialized. So you mentioned monetizations. A monetization is simply where instead of the funding being used solely for kind of going forward or past legal fees and expenses, the client or company receives the funding as basically an advance on the future recovery, to basically bring that money forward now so it can start using it for business purposes. The monetization could be part of a funding agreement where the legal fees and expenses are also getting covered, or the company may have contingency counsels. They don't need funding for the lawyers, but they do want to move forward the recovery. Typically it's still non-recourse, like Jeremy mentioned. So the funders only basis for recovery is if the litigation is successful. If the litigation's unsuccessful, even in the monetization context, and then the funder won't get a return and won't get its capital back. I think we've also started to see law firms exploring how to monetize their contingency interest in cases. So it's not just companies who look at monetizations. It can also be law firms where they might have a significant amount of hours or WIP invested in certain matters that they've taken on contingency or some kind of hybrid arrangement. And the law firms want to move forward their recovery. That could be for end of year reporting purposes or kind of any number of reasons. And they'll look to monetize their future fees with a funder. And one other area it's kind of an offshoot of the traditional model, but companies will often come to funders when they've already got a judgment or arbitration award in hand, and they need financial assistance to go enforce that judgment or award or go collect on it. And so that's another area where I think funders, can be very helpful to companies, because that enforcement process can be, as expensive and timely or time intensive as the underlying litigation just to get to the award or judgment. And again, that's typically non-recourse. So, the funder's recovery is solely premised on the actual payment on the judgment or award, whichever it may be.
Paul, following up on one of the comments Stuart made about law firms using litigation funding perhaps to accelerate recovery of contingent fees to help sort of smooth out the cash flow for the firm. How does that compare to just having a bank line of credit from a utility perspective or cost?
Thank you, David, and thank you for having me here today. So as Stuart mentioned, law firms are a major consumer of litigation finance, specifically firms who are performing plaintiff work on a contingent basis. So law firms traditionally can in fact get lines of credit and get loans from banks, and they to do all the time. But one of the great advantages of having a law firm financed by a litigation funder is the non-recourse nature of the transaction, because unlike a bank line of credit, the obligation to repay the funding is 100% contingent upon receipt of proceeds of the litigation. So not only does it provide a financing function, but it also provides the function of offloading some risk. Basically, selling risk is one way to think about it to a third party, and sharing the risk of loss. Because I hate to tell my clients this, but quite frequently litigations, no matter how great they seem, sometimes you lose. No matter how good the cause of action is, how great the judge is, how great the law is, there's a substantial risk always of losing the claim. And being able to on-sell some of that risk is a tremendous benefit to firms.
Right, that's an important distinction. So the non-recourse nature. And we'll talk a little bit more, I think, about risk allocation and underwriting, certainly in the next series. So while we have you, Paul, tell us a little about, who are the principal parties involved in a litigation finance transaction?
Thanks. Thank you. So as per this slide, there are many parties involved in any litigation and in any financing transaction. But the principal parties are three. And there's a newcomer, which I'll talk about a little bit in a little bit. So the three principal parties in any transaction are going to be the plaintiff, the litigant of the transaction who has the cause of action, the funder, the party providing the financing, and the lawyer or the law firm that is representing the funder. As an aside, I should say that when we talk about funding litigation, we're almost completely talking about plaintiff side litigation. So funding parties that are actually bringing causes of action and seeking monetary reward of some kind. There's an obvious reason why that's of interest to funders, because to the extent that you're successful, there will be a proceed, whether through a settlement or through a judgment. There is a segment of the market for defense side financing. Much trickier, as you can imagine, because very often with defense, there's no proceeds come out. There's simply a savings of money. But it does get, on occasion, it does get used either as part of a portfolio or of cases, which most of which are plaintiff side cases, or in some cases where you're defending a pot of money or some asset, and the funder will take a portion of the surviving assets at the end of the case. So, but back to the parties. So I talked about the plaintiffs. The second major party are the funders themselves. The funders fall into three categories mainly. One is dedicated funders, such as my co-panelist Stuart and his firm. Those investors or investment firms that are dedicated to investing in litigation. Second are going to be multi-strategy investment funds, private equity funds, hedge funds that have as one of their strategies the ability to invest in litigation. And finally, I should mention there's a third category of funders, which I refer to as strategics, either because they have some strategic business reason why they'd like to see the litigation proceed, or in some cases, as the well-known example of Peter Thiel funding Hulk Hogan's lawsuit against Gawker, a grudge of some kind, which is something that we see as well. The third category of participants are the law firms, and either they are plaintiff law firms who are working on a contingent basis and want some financing for their contingency fees. And I should note that increasingly AmLaw 200 firms are increasingly doing plaintiff work and taking work on a contingency basis, and that's something that is a fairly new development. And then finally, we have firms that are working on an hourly basis who have clients who want to bring a case but can't afford their fees. So in many cases, the law firm will work with the funders to provide so that the funder provides financing directly to the client. The The fourth new player, and we'll talk about this a little bit later, are insurance companies. So, and as a reminder, traditional funding accomplishes two things. It accelerates cash flows, provides financing, but it also is a way to offload risk. With an insurance company for litigation insurance, they're not providing you the money, but you're paying them a premium in exchange for them assuming some portion of your risk.
Great, thanks for that overview. And I guess referring back to the Westfleet survey, they talk about a distinction between client-directed and lawyer-directed deals. And they distinguish between single matters, which I referenced above as I think 6 million and change in portfolio, which is about 16 million and change on sort of on average. Stuart, can you help us understand the distinction between client and lawyer-directed deals?
Sure. So, I think, this gets to what Paul was discussing. A client-directed deal is where the funder is contracting with the client, the kind of the law firm's client, to provide that client with funding. Now, that funding is typically used to pay the client's lawyers and kind of other litigation expense, but the funder's actual contractual relationship is with the client, and the client is in charge of, is directing the funding relationship. The law firm directed or lawyer directed arrangements are where, like Paul mentioned, where the funder is engaging directly and contracting directly with the law firm. And the law firm is the direct recipient of the funding and is directing that funding relationship. Now that's often, with a law firm that's taking cases on contingency, and so they're looking for funding to, for whatever reason related to their portfolio of contingency related cases. I think going also back to Paul's comment of seeing kind of more and more AmLaw 100, AmLaw 200 firms starting to explore and use alternative fee arrangements. You're also seeing some more traditional law firms who don't have a big traditional contingency book, but looking to use funding to build out an alternative fee kind of portfolio where they can use funding to take some additional risk on cases without necessarily having to take 100% fee discount on matters. And in some larger firms, we see that it's a lot more palatable to the partnership to take on some funding so they can still get basically some of their hourly rates coming in the door for some of the matters they might take on an alternative fee arrangement, with the potential for significant upside, at the end of the case or cases if they're successful.
Right. And Jeremy, the last point, maybe it's self-evident, but single matter versus portfolio deals, can you expand a little bit on that distinction?
Sure. So it's well, the easy part is the obvious, right? The single case means you have a single case. The portfolio case means you have a multitude of cases that are being funded. But let's talk a little bit about the nuances there, right? So if you are a plaintiff, and let's say you've developed, you have a patent, you've been issued a patent in something, and there's an infringer, right? Let's say it's related to something like a common thing you see, like cell phones, right? There's something that a cell phone does, right? Inevitably, somebody that inventor is going to have a claim against Apple, Samsung, Google, Nokia, whomever, right? So chances are there's going to be a series of cases related to misuse of a patent. That would be a portfolio funded transaction. A single transaction is, let's say, a business dispute, a breach of contract claim between a plaintiff and a defendant. While there's a single case, obviously it's going to be underwritten, and if parties like the merits of it, it'll be funded. So you're talking about funding a single case versus a series of cases or a portfolio of cases. Now, what does that mean from a practical perspective? Usually it goes to the return that a litigation funder may be seeking. If you think about the nature of these being non-recourse, meaning if nothing is recovered in the litigation, the funder doesn't recover anything. It's a much riskier proposition to fund a single case than it is a series of cases. So you may love everything about the facts of an underlying case, doesn't necessarily mean you're going to win. So the return a funder is going to expect in that instance is going to be higher than the return if you can spread that risk over a series of cases. Now, that may not always be true. Let's say, again, let's go back to my example of the inventor with the patent. If it turns out that that patent isn't worth, the paper it's written on, just because you're suing Apple and Samsung and Google and Nokia and whomever else, doesn't mean you're going to recover, right? So, point being, it's a when you have a portfolio, typically it's less risky. Portfolios are used more often, I find, with law firms because they are dealing with multiple cases, although you can fund a single case, and vice versa on the plaintiff side, where it's, an individual party. If they have that patent that they can sue 4 people, then you're in a portfolio situation. If it's just a single defendant, then you're in a single case situation.
Great. So I think we've touched on some of these topics, but I wanted to hit on maybe a little bit of follow-up. Jeremy, maybe we could talk a little bit about some of the policy justifications. What's the solution that litigation financing provides, or what problems does it solve? I'm sorry, this is slide 20 in the presentation.
So I would say a couple things. One, obviously, is the cost issues. If you are that again, take my hypo about the inventor with the patent, right? How are you going to sue Apple and Samsung, et cetera, right? Patent litigation is very, very, very costly, right? And when you have a global behemoth on the other side, they have a whole team of in-house lawyers and external lawyers. So just to get to the point where your case is heard on the matters, is going to be very expensive. That, of course, takes you to the second, which is the access to justice, which is on the slide here. Maybe it's two sides of the same coin, but if that patent is really a good patent, that party should be able to enforce its rights, regardless if the litigation is $200,000 or $2 million or $20 million, right? And as a practical matter, again, going back to the costs, not everybody can support that. The third thing, which isn't, on the slide you're showing right now, but that I think is important, is, if you're talking about law firm funding in particular, right? Lawyers are equipped to practice law and seek justice and things along those lines. Lawyers are not really financing institutions, nor do they typically like to be financing institutions. Lawyers by their nature are typically risk adverse, right? So if you can allow a law firm to practice law without worrying about the financial aspects and risks of that, to a law firm, this makes all the sense in the world. And I think it was Stuart that said it earlier. Traditionally, Am Law 200 firms don't like taking anything other than an hourly billing, arrangement, right? I'm going to do this work. You're going to pay me for the number of hours I spend. That money goes and, gets billed and collected and good. But this opens the universe, because they can still have that type of arrangement with a litigation funder, but now allow parties to have access to some of the best and brightest that otherwise wouldn't have been an option in terms of prosecuting their cases. So what it really does is it levels the playing field, whether you're the poor inventor or, the multi-billion or trillion-dollar, corporate entity.
And David, just to add something to that Jeremy said, the high cost of litigation, even for firms that have plenty of money to spend on litigation, so large corporates, you're looking, the general counsel of that firm is considering whether or not to bring a case, is thinking, this is going to drag, this legal expense is going to drag on my earnings potentially for several years before we can see any return whatsoever. So even though they may have plenty of money to pay costs and to hire the best lawyers in the country, there may be a rational economic decision in which to call Stewart and say, perhaps I'm better off getting funded. They'll take care of the costs. All I will see is the upside when we win, and if we lose, Stewart's going to share in the upside, in the downside.
Right. Would I rather apply that money towards research and development or prosecuting a litigation? And if it means I get a bit less in the recovery, I can deal with that because I've been able to deploy this money for better uses. Absolutely.
Really important point as sort of the highest and best use of a dollar. So Jeremy and Paul, you talked about intellectual property and contingency fee cases. I'll turn to you, Stuart, as the head of originations. What are types of cases that you find attractive? Things that you screen sort of that get past your screens? Is it size, court posture? Tell us a little bit about the types of things that you find attractive and sort of doing your underwriting and evaluation process.
Sure. Thanks, David. I think the things that we look for are very similar to what any funder looks for, and probably, similar to what, I looked at when I was practicing, when a case would get, a new file would get put on my desk and I'd start reviewing it and trying to figure out, is it a good case or not? The first and foremost, is always the merits, factually and legally, is it a strong case? And is there evidence to support it? We see a lot of cases that come to us where it looks like there might be a claim, but the parties don't have the evidence yet to back it up. And as we often take the view, we're not necessarily in the business of providing seed capital to see if they can go find the evidence to support their claim or their damages theory. So that can often be a big issue, and that can be hard because sometimes a plaintiff may not have access to that information until they get deep into discovery, and that can be an expensive process to get to. But I think for the most part, funders want to see that evidence before they make a funding decision. I think the other, other things that we spend a lot of time on are, one, damages. We want to make sure that there's a very conservative, strong damages theory, generally focused on compensatory damages. Our modeling generally strips away things like punitives or trebling, because those can be very hard to get. And we also want to think about what the actual resolution value of the case is. If this case were to settle on the courthouse steps, what do we think that number might be? And that's generally some discount off, the top line damages number. A few other things that are maybe a little different than, when I was practicing, that I didn't think quite as much about, collectability of the defendant. No one wants to get to the end of a case and have a jury find in your client's favor, and then you discover that the defendant doesn't have any assets to pay that judgment, or the assets are hidden overseas somewhere. You're going to have to spend a long time trying to go get it. So you want a defendant that is able to pay a settlement or judgment. You also want to look at, you want rational actors on both sides of the V, both on the plaintiff side and the defendant side. We aren't necessarily looking for cases where there's some, personal animus, that's driving the case. We also, we do look at venue and who the judge is, what court it's in, but a lot of that goes to duration of just how long do we think this case is going to take? Is it going to be 2 to 3 years to resolution, or is it going to be 5 to 6 years to resolution? Those things matter a lot for funders. And when a funder tries to model its return, especially relative to kind of what its investors are expecting from a return perspective. This probably goes without saying, but the lawyers representing the plaintiff are extremely important. As a funder, for cases that we fund, we have zero control over litigation decisions or strategy or over settlement decisions or strategy. So, we're putting a lot of faith in the lawyers handling the case to be able to, to litigate the case well and offer the client good, sound advice on kind of everything related to the case. So we care a lot about that. The last thing I'd mention, well, let me mention two other things. One is, and you alluded to this, Dave, is just the procedural posture. I think for funders, different funders have different kind of risk tolerances about whether they'll fund a case before a motion to dismiss is resolved or kind of where they'll come in procedurally. At Statera, we're pretty flexible and we can come in at any point, but I think different funders have different views of when they're willing to come into a case. And then the last thing is the budget and kind of what that budget is relative to the resolution value of the case. I think our goal at the end of every case we fund is that the client's going to keep the vast majority of any recovery that's received, upwards of 60 or 70%, so that they're better off than if they found a full contingency lawyer that they're giving up 35 or 40% to. But that can only work if our funding is small enough relative to the resolution value that at the end of the day, if the case is successful, our return and any success fee to the law firm is a small enough piece of that pie that the client's going to be able to walk away with the vast majority of that recovery.
Duration is an interesting issue. I'm involved in a project where the parties had fully briefed summary judgment by the end, I think, of middle or end of October of 24, and no decision has been made on the cross motions, and we're 6+ months later, and apparently this particular judge has a reputation for not being speedy. And I know there are courts, they talk about the rocket docket in the Eastern District of Virginia. So how do you get your intelligence on judges and courts? Just from the lawyers or from experience?
Yeah, there's definitely the lawyers who can give you some intelligence from our experience. There's more and more data available out there. Again, it's not perfect, but we use some resources that help us, that look at a court's and can look at a specific judge's, basically history and kind of give you the average duration and kind of give you the 25 to 70% duration. So you can, again, it's not perfect, but it gives you a sense of how long you might be talking about. There are certain courts that can be more challenging. I mean, the New York State Court Commercial Division, has some great judges, but you can file an interlocutory appeal on virtually any issue at any time. And so that creates a lot of duration risk because you can bounce back and forth to the appellate court very regularly, which just slows things down.
The last thing I'll ask on this topic, and then we'll dive into the next one, is just a little bit of self-interest as a firm that provides expert analysis on damages and theories of loss. When you're evaluating cases, do you hire experts, or do you rely on the lawyer's experts, or just your internal expertise?
We typically rely on our internal expertise. We've got, one of our co-founders has a finance background within private equity and ran M&A for a public company and was CFO. So he can do a lot of the internal modeling for us that an expert might do. I think a lot of funders have kind of developed that expertise in-house because that is such an important part of a funder's due diligence, to be able to think about that. And it's, I think it's one of the things that can often be hard for us is that you deal with, when you're talking with lawyers, they have a very strong conviction in the case and, just kind of have a gut feeling that it's going to have a great recovery. And they've got a lot of experience to justify that gut feeling. And that gut feeling could very well be right. We don't necessarily doubt that, but, at the end of the day, funders have to report back to their investment committee and to their investors. And so funders typically need some kind of quantitative, evidence that they can point to support the damages numbers that they're going to rely on to make their decision. And so it's important to have that, like you said, either internally or, to have the expert that the client is using in the litigation who can talk you through the damages theory.
Got it.
But funders make their money on their modeling expertise, right? Their ability to look at a case and a set of facts and quantify how does this play out in a pre-settlement discussion, at summary judgment, at a motion to dismiss, at a judgment. That's how they get paid, right? They are the foremost experts. I mean, I would put any decent litigation funder against any underwriter and damage expert, because that's how they make their living. And they have enough empirical and experience, the good ones anyway, like our colleague Stuart here, to do it and do it well. And if they do it right, then that's when you have a winning formula for everybody.
And we should say that when I'm talking to a client who's getting funded, they're often surprised at the returns that our funders are entitled to receive. And one reason why the returns are high is that the risks are great that funders are taking due to the non-recourse nature of it. But every single one of the bullets on this page that you're showing here represents a separate risk that the funder has to get around to get comfortable with. And so I think it shows you that funders are going to require relatively high returns because they are going to lose cases as well as win cases.
I think we can continue down this road. Sort of they begs the question about the 80-20 rule, which people talk about in venture capital, but I think we need to move on. So the next series will go into greater detail, or the next episode will go into greater detail on the process, but I want to spend a little bit of time touching on the process for securing litigation funding. It's not like you look them up in the yellow pages, I think. So, Paul, when a client comes to you for litigation funding, how do you start the process? What's the path to success in getting funding?
The first thing I tell them is to temper their expectations. So it takes time. It is work to get funding. Funders, I hear different numbers, but funders accept maybe 3 to 5% of the cases, of the opportunities they look at. So they're quite choosy, and for all the risks that we just discussed, the underwriting process is quite thorough. For the good funders anyway. So they advertise a lot, so it's not like they're hiding the funders. They're all over the internet. They advertise like crazy. But I think it is important to understand that funders all have different niches, and depending, some of them fund small cases, some large cases, some look at only certain types of cases, some only look at certain stages of litigation. Some only do portfolios, some do single. So it is important that you not waste your time and look for and go to funders who you know are not going to be interested in your case. So it can be helpful to have an expert with you, partnering with you, helping you find the appropriate funders. For plaintiffs, your attorney. Your attorneys are often going to be the party that you're going to look to help you introduce you to funders. Funders solicit and develop relationships with law firms and attorneys all the time, so they get to know them. But the process can be arduous, and what we tell folks is you need to come prepared when you speak to a funder. That means once you've signed a confidentiality agreement, which is important, you should come prepared with a budget, a timeline, a realistic case outline, something that can really move the process along. The other thing I tell you is when you're presenting a potential funding opportunity to a funder, presumably you signed an NDA, but it is important that you be realistic about the case and discuss both the positives as well as the potential weaknesses to your case. I do counsel my clients not to create a rosy advocacy piece. They're not judges. They're not going to be deciding the case, but it is important that they understand, they see all the warts to the case as well. But the underwriting process, can take weeks or sometimes months. And that is important that clients understand that that the process, the internal underwriting process, can be thorough.
So aligning that process with sort of case progression, Jeremy, do you make your first call a sort of pre-complaint? Think of that might be a pre-revenue kind of situation, or do you need to have gotten past the motion to dismiss, or maybe some discovery? I mean, trying to sort of align those two timelines. When's the optimal time to start the process?
So as cavalier answer, it's when the funder will fund you. But no, I mean, it really depends. If again, I know I keep beating on my hypo, but if you're that small inventor and you can't bring this case without funding, the time to do it is before. If you now keep in mind, right, when we're talking about the risk and the return, as a case goes along, right, certain aspects of the risk go down. So if you're in a position to, let's say, self-fund a case for a certain period of time, see if you can get beyond that motion to dismiss, then, the return that the funder is going to request is going to be less than if it's pre-motion to dismiss, right? So some of it's out of necessity, and some of it's a timing and risk reward equation. But typically speaking, I mean, I've had plenty of clients look for funding, and the funder response will be, well, let's see how this comes out in XYZ stage, right? And that's because, the funder may like the case, but there's something that is questionable about it, or too risky. So that's when maybe you get it later, or maybe you go to funders at the front end, because one thing funders do a really good job of, besides, doing the underwriting, is telling you from their perspective what kind of case you think you have, right? So it serves as a good kind of independent litmus test in a lot of respects. If you've been to 10 funders and they all pass, it may still be a good case, but probably not. If 10 different funders, I mean, because keep in mind, good funders have practiced, right? So they're former practicing attorneys in a lot of cases. And they come from, big firms, big firm backgrounds, big firm experience. So they've seen a lot of these fact patterns and know how they're going to come out. So I know I'm getting a little off topic here, but the point is, David, the time is whenever it's right for both parties. And that could be in the beginning stages, it could be, close to funding or after funding. So it depends on what the pain points are, what the returns are, what the expectations are on both sides, the party seeking funding and the funder.
I imagine you have funders with different appetites for timing, which affects price and risk, and you might get the not no, but not now as an answer, come back later.
Absolutely.
And David,
One of the things that just popped into my head, and I want to ask the question before I forget, is I'm going to use the term adverse selection, but that's probably not exactly the right term. But if a law firm knows they have litigation funding, does that, or how do you control for the risk that they might take more risk because they know there's this non-recourse funding?
I'll jump in, and David, it's a really good question. It's something I was going to kind of actually allude to in response to Jeremy, and David, because I think, or Paul, excuse me, because I think one thing that's important for folks seeking funding is to take a coordinated approach rather than kind of scattershot approach where you kind of approach one funder after another, because the funding world, it's pretty small, and you can pretty quickly realize or intuit if, well, this client has already talked, we think they've already talked to a bunch of other funders who have passed. So, what is it that we aren't seeing? Or, clearly this case has got some issues, so we're going to pass too. Because there's some adverse selection risk if everyone else is passing and it's coming across our desk now. I think on your question, it's a really good one, and it's something that I think every funder spends a lot of time thinking about on the front end. And this goes back to a funder's lack of control over litigation decisions and settlement decisions. The only lever that funders have traditionally is trying to align financial incentives on the front end so that everyone is going to be incentivized to row in the same direction in kind of every reasonably foreseeable situation down the road. And funders do that, through financial alignment, trying to ensure that every party involved has enough skin in the game in terms of kind of what they're investing into the case, as well as enough skin in the game in the outcome, that they've got enough interest in whatever the potential recovery is, that they're going to be acting rationally and reasonably when it comes to kind of how to litigate the case and whether to accept a settlement or whether to go to trial. We don't want, whether it's clients or law firms, thinking they're playing with house money, and always swinging for the fences. We want them to be rational and reasonable when it comes to pursuing the case.
And there are a couple aspects of that besides, David. One is typically you see budgets, right? So there may be an aggregate commitment amount with sub budgets to it. At this stage, pre-motion to dismiss, you have X dollars. Between motion to dismiss and motion for summary judgment, you have Y dollars. So that's another way to control just, a law firm going crazy, right? And throwing 15 attorneys at a matter, because they're not paying for it. The other aspect is you typically see law firms kind of take a decrease from their standard rates. Maybe it's a 25% off standard rates that they bill through, and then there's still some upside for them if there's a successful outcome. So similar to the funders getting paid when there's a judgment, you can also have aspects where law firms will take on some of that as well. And it goes to what Stuart said before about the concept of alignment. So just some other ways you kind of can control that, law firm gone amok.
Yeah, as often happens on these panels, that we get very involved in our discussion and the time passes very rapidly. So as they sometimes say in rebroadcasts, I'm going to speed ahead to a later portion of the program, but I do want to flag that there's some slides in the presentation that talk about the form of the financing and the transaction. These will be on 33, 34, and 35. And I think one of the highlights takeaway here is that what I'm hearing is that the financing is not writing a check on day one, it's all in, it's out of control. It's more along the lines of what I'll call a delayed draw term loan or a revolver, where it's staged and advanced relative to different parts of the case. Before we run out of time, I do want to talk about some very important issues, primarily ethical issues, because we're sort of bringing in third parties who aren't principals, who have different interests in the outcome of the case. So, Paul, we're going to go to talk about some of these ethical considerations. This is slides 24, 29. Maybe you could spend a minute. We'll have you address a couple, and then Jeremy address a couple of the legal doctrines and sort of things we need to think about from an ethical perspective.
I'm happy to jump in to talk about this. Just first to talk about privilege. Although Jeremy, I think you're going to talk about maintenance champerty. Is that right?
Either, that's fine.
Okay, David, whichever you want.
Why don't we talk about privilege? So, well, that's a little earlier. That's slides, or a little later, actually. I think that's slides 30 to 32.
All
So
right, great.
we'll
So
start there.
I'll try to be brief, David. So the question is, will the disclosure of otherwise privileged information to the funder constitute a waiver of the privilege and become discoverable in the case by the defendant? First thing I'll say is a good confidentiality agreement with the funder is an important first step. Overall, the court decisions are pretty mixed about privilege for the most part, but most of them have relied on other things, other principles, and have decided that the information is not discoverable. One is they relied on the work product doctrine, which protects material that's been prepared in anticipation of litigation, and courts have been overall quite protective of that information. But more importantly, courts have relied on relevance, and most of them have determined that disclosure of the existence of financing or the terms of the financing are simply not relevant to the underlying case. So for the most part, there's not been a concern that there's been a waiver of privilege in these cases.
Great. And there are a couple of slides that talk about some of these issues, confidentiality and privilege. So Jeremy will jump back to the ethical concerns that were outlined on slide 24, if you want to walk us through some of these issues.
Sure. So I know we're running short on time. So let's state it like this. So these provisions on maintenance, champerty, and barity, essentially these are medieval principles, legal principles about, having somebody else bring a case or supporting a case where you're not a party to it, or pressuring somebody to bring a claim. And bottom line is that while these were carried over when, the US were colonies and it became part of the law, they've mostly gone away. And most courts have found, and most jurisdictions have found, that these just don't really apply anymore, that you're dealing with sophisticated parties. It's not, so they started with like feudal lords using other people's cases to create issues for rivals, right? That's just not the world we're living in today. And again, at least with the sphere we're talking about, the commercial litigation funding issues, parties are sophisticated enough that they can do their analysis. They have attorneys, they can review these documents. And so the concepts are mostly have been thrown out.
I should say that you should still check the law of the state in which your case is, because there are still some states for which champerty is relevant. Not most of the major states in which litigation is conducted, but it is sort of a state-by-state thing.
Sure, but you're not going to get a funder to fund in those states. So, it'll take care of the issue very quickly.
So in our remaining time, I want to see if we can spend maybe a minute, Paul, talking about contingent risk or insurance, the role that it plays in this process. It seems to be a relatively new development. Can you tell us a little bit more about how it fits into the process?
So in the past 5 years, the biggest, in my view, the biggest change has been the entry of the insurance companies, and you'd think that no one's better positioned to judge risk than insurance companies who've done it since the beginning of time. In some ways, insurers are competitors to litigation funders, but in other ways, they work side by side with funders and actually foster the ability of funders to put more capital to work. There are a lot of different types of insurance that plaintiffs or defendants can obtain through funders. But what I'm going to talk about is the principal type of policy that's most relevant, which is insurance-backed legal finance insurance. So law firms or plaintiffs use these policies. Litigation capital protection insurance, actually. So for a plaintiff or a party that otherwise has an interest in a litigation, such as a contingent fee law firm or a litigation funder, you can insure a portion of that return. So many types of policies exist, but the main ones either insure some type of minimal return on the case. So absent typically a deductible and absence, you won't be able to insure the entire expected return on a litigation. There's also the availability of policies to hedge duration risk. So you may be able to get a litigation policy that says if there's no settlement or judgment within 3 years, the policy will pay off some amount. So the most recent innovation is these insurance-backed finance, where law firms or plaintiffs use policies as collateral for financing. And the goal is to make the funding more cost-effective for the funder to share the risk with the insurer. The existence of insurance has been a big boon to the industry, frankly, as many funders now rely on insurance to mitigate their risk. And the funders, in many cases, are some of the biggest customers and biggest buyers of these litigation policies.
You also
Interesting.
have a different type of insurance product, which is called judgment preservation insurance, which you see utilized a fair amount, which is the situation is, let's say, in the district court, you get a judgment for $50 million against a defendant. You can then go get an insurance policy that will pay out if that gets reversed on appeal. So basically what you're doing, instead of a $50 million judgment, I'm making up these numbers, but maybe you can you pay a $10 million premium and there's a $40 million recovery if it gets reversed. So at that point you talk about, de-risking, you're going to recover the $40 million and maybe you get more, but in any event, it's another product.
One of the things I've been reading about lately and sort of in preparation for this episode is the legislation. So there's legislation in state courts, state legislatures, and in the federal system for governing and regulating the industry and the relationships. And I'm wondering, Stuart, if you could talk a little bit about how some of this legislation affects your business or your decision to invest in a particular situation, and are there states where the option is sort of being legislated out of existence?
Yeah, it's a really good question. I think, we've just seen, more and more activity on the legislative front, particularly at the state level. There have been kind of federal bills percolating for several years, including this year, generally around including, an update to the federal rules of civil procedure requiring disclosure of litigation funding agreements as part of the discovery process. On the backing up more broadly, I think, there's been regulation on the consumer litigation funding side for, I think, a very long time. And I think it makes a lot of sense just given some of the dynamics and involved there. I think where there's started to be some more activity is around regulation of commercial litigation finance. And I kind of break that down between, disclosure requirements of, having to disclose the existence of funding or maybe the funding agreement itself versus kind of the regulation of funding and, what terms funders can or can't put in their agreements and things like that. I think this is Stuart speaking for Stuart, not for Statera. I think some of those reporting and disclosure requirements candidly aren't necessarily a bad thing, depending on how they ultimately shake out. I think from a funder's perspective, we just want certainty as to what the rules of the road are. And, I think generally a funder doesn't want to get involved in lengthy discovery battles about its funding agreement or what was shared or not. If it's treated just like disclosure of kind of insurance on the defense side, where there's no dispute about it, it's just kind of a standard part of the litigation process. I think a lot of funders could probably get comfortable with that. I think when you start talking about regulating the industry more stringently around the terms and agreements, that can start to get a little harder. That's litigation is really unpredictable. It's really uncertain. You kind of never know what provisions you might need in an agreement. And so I think that's where you'll probably see funders potentially pull back or kind of reevaluate their exposure to certain jurisdictions as they pass certain, if and when they pass certain legislation.
We've bumped up against time. As you can tell, panelists are extremely capable and knowledgeable about these issues. We've only scratched the surface. There's a lot more to discuss. And so I encourage you, audience, if you have potential litigation or existing litigation that might be suitable for a funding with Stewart's Group or any other, you should contact Paul or Jeremy or someone who has similar expertise and explore how they can help you meet people like Stewart and perhaps secure some financing. As I mentioned at the outset, we have another episode on May 29th. I thank you for your time and thank the panelists for their participation. Have a great day.
Thank you.
Thanks, David.